All right. So my name is Brittany Mellinger. I am the Fair Housing Training and Outreach Coordinator at the Pennsylvania Human Relations Commission. And today we're going to be talking about fair housing fundamentals. This is going to be an hour-long webinar. We'll have about 45 minutes of presentation as well as some time for Q&A at the end of the presentation. We are recording this session, and we will be sending out the slides, materials, and recording after this presentation. I do ask that everyone double check that you're on mute, and I ask that you stay on mute throughout the entire presentations. That way we can cut back on the background noise. I do encourage you to interact with the presentation, to put comments, questions that you have in the chat. We will get to as many of those as we can throughout the presentation and at the end of the presentation as well. If you're more comfortable asking questions via your voice instead of typing it into the chat, feel free to raise the hand signal, and I will get to you as soon as possible. All right, and with that, let's get started.
I'm sorry to interrupt, Brittany, but can you just make sure that both interpreters are spotlighted?
Yes, thank you.
That's happened. Thank you so much. I don't know if you need Greta's camera on to do that or not.
Let's see, I do have you both pinned now. Will that work?
Not pinned, but spotlighted. Okay. And spotlight yourself as well, so it's not only the interpreter on camera. Thank you.
All right, we should be set. Thank you so much for that. All right, our goals for this afternoon include providing a very brief overview of the Pennsylvania Human Relations Commission, who we are and what we do. We're going to be identifying relevant fair housing laws and protected classes, sharing about what housing discrimination can look like, what acts are discriminatory. We're going to provide information about filing a fair housing complaint, and then we'll have time at the end to answer your fair housing questions. So let's jump in. So who are we as an agency? We have a two-part mission. We both enforce the state's non-discrimination laws, including the Pennsylvania Human Relations Act, as well as the Fair Educational Opportunities Act. And we also work to promote equal opportunities for all in Pennsylvania. So we enforce the non-discrimination law by investigating complaints that come in by people who believe that they've experienced discrimination in the state of Pennsylvania, whether that's in housing, employment, public accommodations, education, or commercial properties. And we have a neutral investigator examine the facts of that claim to see if we have evidence that discrimination has occurred. But in terms of promoting equal opportunity, we do that in a number of ways. We hold these webinars on fair housing topics. We offer trainings as well. So if you'd like a training for your organization, for your agency, please feel free to reach out. I'll have my contact information at the end of this presentation. We also offer various events and conferences throughout the year, so you can always check our website to see what we have going on, and we encourage you to take advantage of those opportunities. We also work with our advisory councils and our ambassadors, who are groups of individuals as well as individuals who work to spread the word about the work that we do and to make sure that everyone is fully aware of their rights in Pennsylvania. So if you do have any interest in getting involved that way, I really encourage you to reach out to me after this presentation. So we cover the entire state of Pennsylvania. And we do that through 3 regional offices. So the western part of the state is covered by the Pittsburgh office. The central and northeastern part of the state is covered by our Harrisburg office. And then the southeast is covered by our Philadelphia office. So here are the two laws that I had mentioned. The Pennsylvania Human Relations Act covers the bulk of the areas that we have jurisdiction over. So employment, housing, commercial property, public accommodations, as well as primary and secondary education. And then the Fair Educational Opportunities Act covers post-secondary education. So college, technical skill schools, and so forth. But today, of course, we're here to talk about fair housing. So that's where our area of focus is going to be. All right, we're going to move on to talk about our laws. The fair housing laws that govern fair housing in Pennsylvania. So most folks are probably familiar with the Fair Housing Act. If you've heard of fair housing, that was signed into law in 1968, that covers the entire country. There's also Section 504 of the Rehabilitation Act, as well as the Americans with Disabilities Act, which provide additional protections for individuals with disabilities. At the state level, we've got a Pennsylvania Human Relations Act, and there's also about 70 different ordinances throughout the state of Pennsylvania, put into place by towns, by cities, by counties that wanted to add additional protections. So there may be additional laws in your area, and I encourage you to check that out to see if there might be additional protections where you live or where you work. So what do our fair housing laws intend to do? Well, the first goal is, of course, to end housing discrimination, to make sure that no one is kept out of their housing based on their protected class, such as their race or their sex, or if they have a disability, things like that. We want to make sure that everyone has equal housing opportunity to live where they would like to live. But there's a second goal that goes beyond that. And that includes promoting diverse, inclusive communities. And in the fair housing world, we call that affirmatively furthering fair housing, or AFFH for short, since it's a little bit clunky. And that means to take meaningful actions in addition to combating discrimination, to overcome patterns of segregation and foster inclusive communities that are free from barriers that restrict access to opportunity based on particular characteristics. We know our country has a history of segregation and of limiting housing opportunities, and it's going to take decisive action to ensure that all of our communities are open to folks who want to live there. So AFFH goes beyond just looking at housing discrimination to ways that we can address the barriers that keep people out of housing in a broader sense. So our fair housing laws cover both the sale and rental of housing, as well as housing related transaction. So housing related transactions is a little bit broader. That might include securing a mortgage or financing for a home. It might be getting an appraisal done for your lender to determine the value of your home. It could be getting homeowners or renters insurance. Any of those transactions that surround the home buying process or the rental process. And our fair housing laws cover the vast majority of types of housing. It could be anything from apartments to single family homes, manufactured home parks, condominiums, public housing, nursing homes, dormitories for students, and more. And when we look at the types of housing discrimination, there's two main types. The first one, disparate treatment, is what a lot of folks think of when they think about housing discrimination. So that's treatment that directly discriminates against a member of a protected class. So I'm not going to rent to you because you have a disability. Disparate impact is a little bit more insidious. It is a policy that impacts members of a protected class. It often seems pretty neutral on its face, might not reference the protected class, anything like that, but it still has an impact. So instead of saying, you know what, I'm not going to rent to you because of your disability, it might say, instead a housing provider might say, I'm going to have a policy that all tenants must have earned income from work, from their employment. Well, that might have a broader impact on tenants who have a disability, or prospective tenants that have a disability who may not be able to work, but who may be receiving income from other sources. And that would have the impact of excluding them from that housing unnecessarily. All right, so next we're going to move on to protected classes. Before I jump in and show you the slide with them, I'm curious how many we could identify in the chat. Could anyone put in a protected, either at the federal or the state level, groups of people that have fair housing protections? I'll take a quick beat, see what y'all can come up with. I do see a bunch of my colleagues on this call, so I think we can probably get there. Yep, race, absolutely. Age over 40, that's protected at the state level. What else? Religion, yeah. Disability, absolutely. Gender or sex, yeah. Absolutely. Anything else? Sexuality, we'll get into that in just a minute. Guide or support animals, yeah. All right. Sex including LGBTQ now, yes, we will get into that. I've got a slide on that in just a moment. So it looks like we got most of them. Yep, religious beliefs, ancestry is at the state level, absolutely. Good job, everyone. Economic status is not a protected class, but it certainly can impact housing opportunities. Absolutely. So I've got a list of both the protected classes at the federal level under the Fair Housing Act on the left. So you'll see race, color, national origin, familial status, religion, sex, and disability. So that's the 7 big ones that are throughout the entire country. On the right-hand side of your screen, you'll see the protected classes that are protected under the Pennsylvania Human Relations Act. So you'll see they're very similar: race, color, national origin, familial status, religious creed, very similar to religion, sex, and disability. But we've got 3 additional ones that aren't protected at the federal level. So there's age, 40 and above, there's ancestry, as well as the use, handling, or training of support animals for disability. So, as I mentioned earlier, you may have a local ordinance in your area that provides additional protected classes. One that we see in a couple areas of the state is source of income protection. So the type of income that you receive to housing costs could be a Section 8 voucher, something like that. There are several areas of the state, including Philadelphia State College, that have that protection, but it's not available statewide. We'll take a quick second to define a few of our protected classes in a little bit more detail. So familial status, that covers a couple different groups. That covers families with children who are under the age of 18 that live with their parents or their legal custodians. That covers people who are pregnant, and it also covers people who are securing custody of children under the age of 18, including foster children. So those groups of individuals couldn't be denied housing or housing-related services based on their familial status.
Good.
All right, there are a few exemptions to familial status protections based on age. There, through the Housing for Older Persons Act, there's a few types of communities that do not necessarily need to have families with children living there. So the first is 55 and over communities, and those have 80% of units that must be occupied by at least one person who is 55 and older to maintain their status. They do need to advertise and market as for folks who are 55 and older. Only one resident needs to be 55 or older. However, there can be age limitations that can be placed on other tenants, and residency and access to facilities and services to children and to other folks who are under age 55 can be in place, but they do need to be consistent in the way they apply their rules. 62 and over communities have a little bit stricter rules. So they need to be certified. You need to be age 62 or older to live there. So obviously kids who are under the age of 62 would not be permitted to live there. So there is that exception for certain senior living communities that wouldn't need to permit children to live there. And there are some comments in the chat about LGBTQ protections. So in the list of protected classes, both federally and at the state level, you didn't see sexual orientation, gender identity on that list. However, we do have those protections under the protected class of sex. So through regulations, we've defined the term sex to refer to sex assigned at birth, sexual orientation, transgender identity, gender transition, gender identity, and or gender expression. So we use those regulations as we accept complaints, as we conduct investigations, and as we adjudicate cases. So, so if you do believe that you've experienced housing discrimination or other types of discrimination that are under PHRC jurisdiction, you can file that under the protected class of sex. And lastly, I want to take a second to define disability. So under fair housing laws, disability is defined as a physical or mental impairment that substantially limits one or more of a person's major activities. Examples of this can include caring for yourself, walking, seeing, hearing, speaking, breathing, learning, or working. Now, an individual with a disability, it might be very obvious that they have a disability. It might be less observable as well, but regardless, an individual with a disability does have fair housing protections, and we'll get into reasonable accommodations and modifications a little bit further towards the end of our program. But fair housing laws protect those who have a disability, who have a history of a disability, as well as those who are perceived as having a disability. So all three groups do have protections under fair housing laws, because even if you don't have a disability, but you're perceived as having disability, you might be treated differently in your housing. Or if someone knows of a history of a disability, particularly one that might have some stigma attached to it, there could be a risk of you being treated differently. So, so all of those individuals do have protections. I do see a question in the chat about sending the slides out after the presentation, and we will send the slides. We will also send further resources on fair housing topics, since I recognize that an hour is not enough time to cover all areas of fair housing. So we'll send out some resources as well as contact information if you have further questions after this presentation. All right, so we're going to take the next chunk of our presentation and talk about acts that are discriminatory, that are prohibited under our fair housing laws. So the first one is discriminatory statements. Housing provider cannot print or circulate statements that would indicate a preference or a limitation related to a protected class. Some examples that you see on the screen here would be near a Catholic school, perfect for empty nesters, near a Korean grocery, or great for singles. These indicate a preference for a certain type of tenant, so, or occupant, home buyer. And as such, some other folks that don't necessarily fall into these categories might feel less welcomed or think that they may not qualify for housing. Therefore, it's important that that housing providers do not make discriminatory statements, whether it's in a newspaper, whether it's on a Facebook Marketplace listing, on Craigslist, wherever a housing is advertised. Avoid any statements that might indicate a preference for who would live there. A better way to go about it is to simply describe the housing itself, not who you think would be a good person to live there. A housing provider may not make housing unavailable by refusing to sell, lease, finance, or withhold housing or commercial property. So some examples of this include a realtor not showing homes to a Latino couple because the seller knows that the neighbors don't really want those kinds of people in their neighborhood. That would be an example of steering. A bank refusing to lend money to a woman who's pregnant because she can't prove that she will go back to work after the baby is born. Well, that would be lending discrimination based on sex and familial status. Falsely stating that a property or a unit isn't available when it actually is because the landlord thinks that the prospective tenant is too old to live independently. That would be denying housing, could be based on age or potential disability as well. So the housing provider may also not discriminate in the terms or conditions of sale, lease, or financing. So some examples of this include having higher fees for families with teenagers. That would be familial status, right? Charging an extra security deposit for service or support animals. That would be impacting individuals with a disability if they need that animal for support. Of course, that doesn't include pets. Pets can have an extra security deposit, but if an individual with disability does need an animal because of their disability, you can't charge those extra fees. And lastly, a housing provider couldn't increase monthly rental costs just for residents of certain races. That would be clearly discriminatory. All right, so we need fair treatment in who is able to access housing. The terms and conditions, they have to be fair as well. And also, once you're living there, you need to have equal access to the facilities, services, and privileges, whether that's connected with ownership, occupancy, or use of housing or commercial properties. So some examples we have here include not allowing children to use the pool, or any other areas of the facility. Could include ignoring or taking longer to complete maintenance requests based on a particular class, or applying rules of or lease provisions differently for members of protected classes, such as enforcing overnight visitor policies, but only for women. Maybe enforcing noise violations, but only for members of a certain race. Have to make sure that as you're enforcing the rules, as you're providing access to the facility, providing services, it all has to happen fairly as well. All right, discriminatory inquiries are legal. So that would be making an inquiry or record related to a protected class in connection with sale, lease, or financing. So this could look like asking if someone has a disability on a mortgage application, or asking a caller if they're inquiring about an apartment for their age or if they have children. A housing provider doesn't really need to know this information. They shouldn't be making any decisions based on it, so it should not be part of the conversation as they're meeting prospective tenants. Shouldn't be part of the application. If a person is applying to certain HUD subsidized properties, certain affordable housing units, there may be a demographic screening, but that is completely voluntary, and that's the purpose of that is not to make a decision on whether that individual can access that housing based on that information, but that's so that there can be appropriate data collected about HUD programs and who they're serving. All right, we mentioned steering a little bit earlier in the presentation. That's defined as attempting to induce listing, sale, or other transaction, or to discourage purchase or lease by making direct or indirect references to either the present or future protected class composition of the neighborhood. There was a a study done a few years ago in Long Island. It's called Divided, that was done, showing that steering does still happen today, and there's a lot of coded language that's used to encourage folks to seek housing in certain places, to have them seek housing other places. But that steering is illegal. Everyone deserves to have equal access to the knowledge of what housing is available and to make their own decisions on what they want in their housing based on the needs of their household, not based on the needs or the perceptions of the realtor, the property manager, or whoever is showing the housing. All right, lending discrimination is unlawful, and that could include targeting people for unfair or deceptive loans based on protected factors such as race, sex, or age, or refusing to provide services. There was a major settlement, I believe it was last year, $20 million across 4 states in the greater Philadelphia area. They were found to have been distributing racist language about minority and majority areas, avoiding providing services and loans in minority majority neighborhoods, and targeting their advertising solely to majority white neighborhoods or the vast majority of their advertising. So there was a settlement that required them to pay out because it's important that everyone has equal access to lending products that allow them to buy a home. All right, unreasonable use of criminal history is prohibited. So HUD did release some guidance in 2016, and that states that a person's criminal history cannot be the sole factor in denying housing. Arrest records cannot be used in the application process, since if it's just an arrest record, there's no conviction. So that should not be used. A housing provider, landlord, or property manager is required to consider the person in their entirety. So it's recommended that a housing provider use multiple factors when they're looking at whether to approve or deny an applicant, including reference checks, credit score, income, and employment. And they should make a case-by-case analysis. If they do turn up a criminal record that looks at how recent the offense was, how severe it was, how relevant it was, as well as any mitigation efforts that have happened since the offense, to look and see if someone is actually a risk to other residents or to the property, rather than simply just excluding everyone that has a criminal record. I want to touch briefly on appraisal bias. So that's the use of protected classes when determining the fair market value of a property. So this is often used as someone's buying a home or perhaps refinancing their home. It's been featured in the news in the past few years. It's often called whitewashing a property to receive a fair appraisal. So we often see it with homeowners of color who receive what they feel is a low appraisal, and they go to get a second appraisal, but they take out anything from their home that might indicate that they're a household of color. Take out the family photos, the art, anything of that nature, and have a friend or a family member stand in, so that way it appears to belong to solely white household. And there have been numerous incidents that have been uncovered through testing that have found that that after the home has been whitewashed, that the household did receive a higher appraisal. So this is obviously a significant issue as we're looking at racial equity and in wealth and home ownership, because if households of color are not receiving appropriate valuations of their property, it keeps them from being able to take advantage of the equity in their home. So that's why the Biden administration has taken efforts to study issues within the home appraisal industry. And they do this through the PAVE task force, which is called Property Appraisal Valuation Equity. So they put together a whole report as well as action plans with next steps that address this issue. There's a link there that you can check out after the presentation. But it looks at diversifying the field of appraisers, providing greater accountability for appraisals, looking at the methods that are used to make sure that that people are having their homes appraised fairly. All right, and the last action that I want to touch on before moving on to the complaint process is refusing to make reasonable accommodations and modifications. So individuals with disabilities, of course, have all protections against all of the discriminatory actions that we've covered so far, but they're also entitled to having reasonable modifications and accommodations that they need because of their disability, that they need to use and enjoy their housing. So reasonable modifications are a structural change that are made to the premises. So this could include installing a ramp, lowering countertops, installing a grab bar, any physical change that you might be making to the structure that allow a person with a disability to be able to use the property. A reasonable accommodation, in contrast, is a change, exception, or adjustment to a rule, policy, practice, or service. So some examples of this include allowing a person with a disability an assistance animal when there's a no pet policy. So this could include either a service animal or an emotional support animal that the individual needs to use and enjoy their housing. So even if a housing provider says, nope, can't have any pets, or there's breed restrictions or extra fees for pets, these things wouldn't apply to an assistance animal, since this animal is an extension of the individual with a disability that they need, whether it's for emotional support, whether it's for assisting them to around if they need that, whether it's to detect diabetes, blood sugar drop, things like that. Assistance animals can do a wide range of things. And I know there's often confusion in the process of requesting a reasonable accommodation to have an assistance animal. And we do have an entire separate presentation that is directed just at reasonable accommodations, assistance animals, things like that. So if you do want further details on that, happy to answer questions in the Q&A, but we also do provide a more specific training on that as well. Another example is reserving or designating a parking spot that's needed for an individual with disability. There might already be a handicap parking spot on the property, but it might not meet the needs of the individual. It might be open to anyone with a disability that needs to park there. So it might not be available at all times. It might not be close enough to the person's unit. So there may be a need for reserving a specific parking spot. So that's an example of another reasonable accommodation. All right, we're going to move on to the complaint process. So if you believe that you've experienced discrimination in your housing, encourage you to file a complaint with our agency so that way we can investigate it and look into it. So that starts with the intake process. So starts out with requesting information. So you can go online to our website, get information there, get the complaint forms there. You can call our office. You can email us, get that process started. So when you talk to a staff person, you'll fill out a questionnaire and get assigned to an intake investigator. That investigator is going to assess the information that you provide, make sure that the complaint is timely, So make sure it's within the 180 days that we have where you can file a complaint, and make sure it's jurisdictional. Make sure it's something that's covered under our laws that we can actually investigate and enforce. So there'll be an interview with your intake investigator, and if the complaint is found to be timely and jurisdictional, that intake investigator will help to draft that complaint, and it'll get sent back for signature and verification. In the past, we did it by mail. I believe we can also do it by email as well. So once that signed complaint is received, then that complaint is filed and the investigative process can begin. Now, if we find in the process of that intake that the complaint isn't timely, it isn't jurisdictional, then that complaint can't move forward with our agency. But if it's appropriate to be filed with a different agency at the federal level, whether with the EEOC or with HUD, we can provide that referral and that information. And then if the complaint isn't signed, if it isn't returned, the process can't move forward until we would receive that back. Let's say we receive the signed complaint back, then it's filed, it's docketed, and the complaint is served both to the complainant and the respondent. It's then up to the respondent or the person who is being accused of the discriminatory action to answer. And at that point, the investigation begins. So at this point, our investigators are completely neutral. They're not on the behalf of the person who files the complaint. They're not on behalf of the person that's responding to the complaint. They're just there to find out what happened and to discover the evidence. So they can do that through a fact-finding conference, bringing both parties together. They may request documentation. They may call or email to get further information. The complaint can be settled voluntarily before there's a finding, or the investigation can continue until there's a finding. So the finding could be no probable cause, which would mean that there was not enough evidence to determine probable cause of discrimination. If the agency would determine no probable cause, the complainant could appeal that if they believe that that finding was not correct. If they do find probable cause, then there would be a conciliation effort. So they would attempt to settle that between the complainant and the respondent. If the complaint isn't settled, it would progress to a public hearing where they would either find that discrimination did occur or that a charge is not established. So it is a little bit of a process. It does take some time, but the agency is very thorough in making sure that complaints are fully investigated to make sure that folks have a remedy when they're filing a complaint because they believe they've experienced discrimination. All right, so some potential housing case remedies are results if discrimination is found, or if there's a settlement or a conciliation, things that can be obtained to right the wrong that's happened. So it could be that the property is leased or sold. Could be stopping an eviction that was in process because of the discriminatory actions. Could be that a reasonable accommodation is granted or the modifications are made to the housing unit. Could be changes to the housing agreement, such as the lease. Could be a broader policy change that happens at that property, at other properties that the housing provider owns. That ensures that discriminatory actions don't happen to other folks as well. Housing provider could be required to post fair housing notices that are put out by PHRC. The housing provider may need training could be a one-time training, could be over several years, to make sure that all of their staff, everyone at their agency knows what their fair housing responsibilities are. So that way we prevent future housing discrimination issues. Could be that there were fees that were charged erroneously. Those could be reimbursed or forgiven. There may be civil penalties that are due to the state because of the actions of the respondent, and the complainant may be reimbursed for out-of-pocket expenses. So in the middle there, you see money for humiliation and embarrassment highlighted. That's because this is only available in housing cases. These other remedies might be available in employment or public accommodation cases as well. But this money for humiliation and embarrassment, pretty similar to pain and suffering, that's only available in housing. I'd like to highlight a few recent housing awards. So one was for $1.5 million. That's a housing provider that failed to provide accessible units and ignored requests for reasonable accommodations for tenants with disabilities. There was a $100,000 case where a maintenance worker sexually harassed a female tenant. $80,000 where a housing provider subjected African-American tenants to racial harassments, and $9,000 where an HOA refused to sell a condo in a 55+ community to a man with disabilities and his wife after they asked for that reasonable accommodation of having their daughter, who was under 55, to be able to live there. So that's just a few examples of housing awards. We take fair housing protections very seriously at this agency because it's the right of every Pennsylvanian to have fair housing opportunities. All right, some resources that we have available to you include our Fair Housing Line. You can see the number there on the screen. If you have questions or concerns, you're looking for further information, want to know how to file a complaint, give us a call. We've got staff that are available to answer your questions, provide that information. In addition to these webinars, we can also provide custom fair housing training and consultation for your agency or your community's needs. We provide trainings to both to housing providers, to municipal officials, to social service agencies, to community organizations, really whoever is looking for them, because we want to make sure that everyone has equal access to this information. We've got this webinar series, Fair Housing Power. So we do this every month. It's the last Wednesday of the month, 12 to 1. So spend your lunch hour with us. Next month, on August 30th, from noon to 1, we'll be talking about national origin. So we'll be talking about protections for folks who are born in other countries. We'll be covering language access, translation, documentation, all of that important information that's good to know if you're a housing provider or a community member that needs to know this info. We also have September's, which will be September 27th, and that's going to be covering LGBTQ protections in more detail. So please sign up for those. I'll send out the links to registration at the end of this webinar, probably in the next few days. We also have a series called PHRC Speaks, Fair Housing in the 21st Century. That's broadcast on PCN TV. It'll relaunch again later this fall. And we talk about topics that relate to housing opportunities, partners throughout the state that are doing good work in expanding housing opportunities. All right. And I promised contact information as well, so you can see the info for our central office as well as my information. You can feel free to reach out to me by phone or email, as well as call our Fair Housing Line. So at this point, I want to take a look at the questions in the chat. I see there were a couple that were highlighted here, so give me just a moment to look at it. If the building is located with public parking, is it with public parking only, is the responsibility of the building or the disabled person to get the stop put out on the street? So I'm assuming this is a reasonable accommodation request of an individual that needs parking. There's public parking there. Encourage that person to talk to their municipality to put that reasonable accommodation request to get that designated, since if the parking is out on the street, it wouldn't be the responsibility of the housing provider. It would be the township, the borough, the city that would be responsible for designating that parking. So I would start there. All right, there's a question: to what extent do these requirements, reasonable accommodations, apply to short-term rentals like VRBO or Airbnb? That may be, I will look into that to get an answer for you on that. I believe VRBO or Airbnb short-term rentals may be covered under a different section of our law, not under the Fair Housing Act, depending on the length of time of stay. But I will certainly get some further information, and I'll send that out with the rest of the resources. All right, I see a question about the example cases. What did they do to get their case heard? Isn't it often that the people who need help most can't afford the fees to take their concerns to court? You don't need an attorney to file a case with PHRC. Any individual that believes that they've experienced discrimination in housing can go ahead and file on their own. They can work directly with the intake staff, with the investigator to get their case investigated. If the agency does find probable cause, if we find that there is enough evidence of discrimination, then at that point, after that probable cause finding, then the agency works on behalf of the individual, the complainant that filed, to resolve it, either whether that's through conciliation or whether that's going to public hearing. Okay, I think that is all the questions that I see so far. We still have about 10 minutes left. If you have questions, please feel free to raise your hand to ask a question, put a question in the chat. Happy to take this time to make sure that we have your questions answered. Okay, I see another question. Is there any way to address how difficult it is to rent a home or apartment? Such as the landlord specifies on the advertisement that you must make 3 times the rent per month. So if the rent is $2,000, they expect you to make $6,000. I do know that that's a significant issue, and that's a barrier for a lot of households to have that income, to have that money up front. I do know that the Biden administration is working on increasing renters' protections through the Renter Bill of Rights, which they've been putting out information over the past few months. So I'd encourage you to check that out, and I can put the link to that. But at this point, in Pennsylvania, the housing provider is able to require 3-4 times the amount of rent, and that's not an issue as long as it's done fairly without having an impact on individuals in protected classes. All right, Marjorie, I see your hand up. Please feel free to unmute and ask your question.
Hi, Brittany. My question is, I live in an apartment complex, and that's actually why I wanted to get on this call. I did learn stuff for work, which is great. But I wanted to know if that an apartment complex can charge different rents, and I'm talking like hundreds of dollars difference for the same size apartment with the same amenities. That's the first question. And it seems to be based on, you know, like when people have moved in and how long they've been here, that sort of thing.
I do know that that housing providers do charge different amounts of rent. It can't be on the basis of any type of protected class, but I know especially affordable housing providers will often have different amounts of subsidies. So like there'll be different charges, different rental amounts. So that's pretty common, especially if they have several different funding streams supporting the same unit.
Yeah,
there.
that's not the right. That's not the case in this example. It's just people paying regular rent without subsidies. So you're still saying that's permissible.
That's permissible as long as it's not discriminatory based on a protected class.
Okay, and I guess that would hold true also with rental increases, that they could have a rental increase of 170 for somebody and $40 for somebody else per year.
Yeah, that's largely up to the discretion of the housing provider, but again, it should be done in a fair way. If you do believe that it's based on a protected class, or if it's in retaliation for exercising fair housing rights, that would be something that you'd want to report and file a complaint based on. But a housing provider does have discretion on doing that. And I know some housing providers have some tenants that have been there for years and years and years and might have a lower rate that they need to kind of catch up to someone that's rented more recently. But there aren't strict laws around that in Pennsylvania, even though there are rent control laws in other areas of the country.
And if you were interested in trying to get what you said, a rent control law in Pennsylvania, would you talk to your legislators?
Yep, absolutely. Talk to your legislator. A legislator, they might be working on this issue, or they might be able to point you to other advocacy groups in the area that are working on that issue.
Okay, awesome. Thank you very much. I appreciate it.
Absolutely. Great questions. Thanks for asking. All right, I see a question in the chat on the state or city of Philadelphia reassisting families facing rental evictions. I know that's a significant issue for a lot of rental households. And I know that there were significant funds that were available during the pandemic through the Emergency Rental Assistance Program, available to assist households that have now run out. From what I understand, a lot of the programs that are available now are based on where you live, on certain criteria. It's a little bit more scattered and piecemeal than what it was throughout the pandemic. I'm not aware of significant funding like ERAP, the Emergency Rental Assistance Program, that was available during that time. That'll be coming through the state or the city right now. 211 is usually a pretty good resource for getting connected to different providers in your area that might be able to assist with rental assistance, eviction prevention, things like that. I know a lot of smaller programs have kind of sprung up because there is a really significant need to keep households stable in their homes and preventing evictions from going on records and preventing future housing stability. All right, we've got just a few more minutes. Any last questions that folks have? Well, if not, I'd like to thank you all for joining me today. Really appreciate all the great questions, all of the attention that you've paid. As soon as I close out the Zoom meeting, there'll be a short survey that pops up. Promise, it's just like, I think 10 questions. It'll take 5 minutes or less. And it gives us a lot of really great feedback on what you thought of the presentation, what you would want to see going forward, because we're always looking to make sure that these presentations are meeting the needs of attendees and are clear and understandable. So Thank you again. Enjoy your afternoon, and I hope to see you at a future training.